Certain properties and situations are exempt from the federal lead-based paint disclosure requirements under the Residential Lead-Based Paint Hazard Reduction Act, Title X. Here's a quick list of those exemptions. Exempt from lead-based paint disclosure requirements. Properties built after 1977. Lead-based paint was banned for residential use in 1978. Housing for the elderly or disabled. Only if no child under the age of 6 is expected to reside there. Foreclosure sales. Foreclosed homes are exempt from disclosure laws. Short-term leases of 100 days or less, provided there's no option to renew or extend the lease. Lease renewals. If the original disclosures were properly made and no new lead hazard information has been discovered, 0-bedroom dwellings, such as studio apartments or lofts with no separate sleeping area, sales or servicing of mortgages. This includes transfers like refinancing and loan servicing. If a property was built before 1978 and then remodeled, does the owner still have to disclose lead-based paint if it was all removed? The owner still must disclose the possibility of lead-based paint unless they have official documentation proving the property is now certified as lead-free by a state-approved or EPA-certified lead inspector or risk assessor. Here's a breakdown. If a pre-1978 home was remodeled, disclosure is still required unless the property has been inspected and certified lead-free. Simply removing or painting over lead-based paint is not enough to avoid disclosure. The seller or landlord must still disclose any known information about past or present lead-based paint or hazards. Provide the EPA pamphlet. Protect your family from lead in your home. Offer any lead-related reports or records. Allow the buyer a 10-day window for lead inspection, in sales unless waived. What counts as certified lead-free? To avoid the disclosure, the home must have a written certification from a state-approved lead inspector stating there are no lead-based paint or lead-based hazards present. This is often called a lead-based paint inspection report or risk assessment report. If there's no official clearance report, even if the owner believes all lead-based paint was removed, they are still obligated to disclose that the property was built before 1978 and could potentially contain lead, unless proven otherwise. Remember, it is not just paint on the walls. It could be in the plumbing or wiring or underneath old remodeled jobs done in the past. The laws governing penalties for non-disclosure of lead-based paint hazards are primarily found under federal law, specifically within Federal laws governing penalties. Residential Lead-Based Paint Hazard Reduction Act of 1992, Title X, Section 1018. This applies to sales and leases of most residential housing built before 1978. Requires sellers, landlords, and agents to disclose known lead-based paint hazards and provide the EPA pamphlet. Penalties for non-compliance. Civil penalties up to $21,018 per violation, adjusted annually for inflation. Each real estate transaction can be considered a separate violation. No warning is required before penalties are assessed. Toxic Substances Control Act, TSCA, Section 409, 15 U.S.C., paragraph 2689, authorizes the EPA to enforce lead-based paint regulations. Penalties include civil fines up to $25,000 per day per violation, criminal penalties under TSCA, paragraph 2615b, for knowing and willful violations, fines up to $25,000 per day, imprisonment up to 1 year, EPA's lead renovation, repair, and painting, RRP. Rule regulated under 40 CFR Part 745 applies to contractors, landlords, and property managers disturbing painted surfaces in pre-1978 housing or child-occupied facilities. Enforced by EPA in some states if authorized. Penalties, same as TSCA. Civil and criminal penalties apply. Failing to follow safe work practices or lacking certification can result in fines and legal action. Other legal risks, beyond statutes. Private lawsuits. Buyers and tenants can sue under negligence, breach of contract, breach of warranty of habitability, fraud or misrepresentation, state real estate licensing laws, e.g., the Arizona Department of Real Estate, ADRE, can issue reprimands, license suspension or revocation, mandated retraining risks of non-compliance with lead-based paint disclosure laws, Civil fines and penalties, Title X, Section 1018, up to $21,018 per violation, adjusted for inflation. Each transaction with missing or incorrect disclosure may be treated as a separate offense. No prior warning is required before penalties are issued. Lawsuits and legal liability. Buyers or tenants can sue for damages if harmed due to lead exposure. Real estate agents, landlords, and sellers may be held jointly liable. Claims may include fraud, negligence, or breach of contract. Criminal charges. Willful violations can result in criminal prosecution under federal law, 15 U.S.C., paragraph 2615b. Penalties may include fines up to $25,000 per day and up to 1 year of imprisonment. License and regulatory sanctions. State real estate commissions, e.g., ADRI in Arizona, may investigate for professional misconduct. Disciplinary actions can include formal reprimands, mandatory education or retraining, suspension or revocation of real estate license, damage to reputation and business. Non-compliance undermines trust with clients and the public. Agents and firms risk loss of referrals, bad reviews, and reduced business opportunities. Failure to protect clients' health and safety can have lasting reputational harm. Who must comply with the 2008 Lead Renovation, Repair, and Painting RRP rule? Anyone paid to perform work that disturbs painted surfaces in residential properties or child-occupied facilities built before 1978 must comply. This includes property owners and managers of rental housing, general contractors, specialty trade professionals such as painters, plumbers, carpenters, electricians. What activities fall under the LEED RRP rule? Any work that disturbs painted surfaces in pre-1978 housing or child-occupied facilities, such as remodeling and general repairs, electrical or plumbing work, interior or exterior painting, carpentry window replacement. What properties or activities are exempt from the rule? The RRP rule does not apply to homes built in 1978 or later, housing for elderly or disabled individuals, unless children under 6 reside or are expected to 0-bedroom dwellings, e.g., studio apartments, dorm rooms, properties or components certified as lead-free by a licensed inspector or risk assessor. Minor repairs are disturbing. 6. SQM F tier of painted surface per room, interior, or Titro 20 SQFTU on the exterior. Note, this excludes window replacement, demolition, or other high-risk activities. What does the rule require? Pre-renovation education, effective now. Before starting work, you must provide the EPA Renovate Right Lead pamphlet to the owner and occupants for residential work, or an adult representative for child-occupied facilities. For multifamily housing or shared child-occupied facilities, distribute notices or post visible informational signs describing nature of the work, location, and dates. How to obtain the LEED pamphlet. Obtain confirmation of receipt or a certificate of mailing. Keep all related records for 3 years. Exception. These education requirements do not apply to emergency repairs, e.g., responding to a child with elevated blood lead levels. Training, certification, and safe work practices. Effective. April 22, 2010. Firms performing the work must be EPA-certified individuals. Doing the work must be trained and certified renovators, must use lead-safe work practices, such as containing the work area to prevent dust debris spread, avoiding prohibited methods like open flame burning, or using power tools without HEPA filters. Performing a thorough cleanup and post-cleaning verification. Exemption from these requirements is allowed only if the property owner signs a statement confirming it's their personal residence. No children under 6 or pregnant individuals live there. It's not a child-occupied facility. They understand the LEED-safe practices will not be used. Timeline of implementation. April 2009. EPA begins accrediting training providers. October 2009. Firms may apply for EPA certification. April 22, 2010. Rule becomes fully effective. All requirements must be followed. Lawsuits involving lead-based paint are serious and have resulted in multi-million-dollar judgments against landlords, property managers, and even paint manufacturers. These cases typically arise due to non-disclosure, failure to remediate known hazards, or negligence leading to lead poisoning, especially in children. Here's a breakdown of the key types of lead paint lawsuits and notable examples. Common legal grounds for lead-based paint lawsuits: failure to disclose under federal law, Title X, Section 1018 of the 1992 Residential Lead-Based Paint Hazard Reduction Act. Sellers and landlords must disclose known lead-based paint hazards in housing built before 1978. Lawsuits often result when tenants or buyers later discover hazards that were not disclosed. Negligence. Property owners may be sued for failing to maintain the property in a lead-safe condition, especially if peeling or chipping paint was visible and not addressed. Personal injury. Toxic. Tort. Tenants, often parents of affected children, file personal injury claims when children are diagnosed with elevated blood lead levels, leading to developmental issues. Breach of warranty or habitability. Tenants may claim a violation of the warranty of habitability, arguing that the presence of lead paint makes a home uninhabitable. Product liability. Paint manufacturers have faced lawsuits for marketing lead-based paint as safe, even after the health risks were known. Notable lead paint lawsuits. Baltimore MD, series of tenant lawsuits. Baltimore has seen thousands of lawsuits over the years from tenants of older rental properties. In 2019, a family was awarded $2 million after their child suffered brain damage due to lead exposure in a rental unit. Milwaukee lead poisoning cases. In 2020, families sued landlords and the city of Milwaukee, claiming systemic failure to inspect and notify tenants of hazards. Some cases led to multi-million-dollar settlements. California lead paint manufacturers lawsuit. In 2014, a California court ordered Sherwin-Williams, NL Industries, and ConAgra to pay $1.15 billion into a fund to clean up lead paint in homes across 10 cities, counties. The court ruled that the companies had created a public nuisance by promoting lead paint despite knowing the risks. Potential consequences of lawsuits: massive financial liability, settlements, damages, medical costs, permanent record of violations for landlords or firms, loss of insurance or increased premiums, criminal charges in extreme negligence or fraud cases, damage to reputation and trust in the community, loss of trust in the due diligence of agents, how to reduce legal risk. Always comply with disclosure laws for pre-1978 housing. Keep detailed records of all disclosures, inspections, and repairs. Hire certified professionals for renovations or repairs involving painted surfaces. Promptly address any signs of chipping or peeling paint. Provide tenants with the EPA's Protect Your Family from Lead pamphlet.